Hello students. So in this video, we are going to talk about the recent controversy which was between the judiciary and the government. That is the collegium on one side and the central government on other side. Now what was this tussle? We have seen a lot of news about the erstwhile Law Minister Kiran Rijiju commenting that how this collegium system has to be removed and NJAC has to come in order to appoint the judges to Supreme Court and High Court. Now what is this collegium system? Let's try to understand this, right? Now the collegium is a body which appoints, at the same time transfers the judges. There are two tiers of collegium. One is Supreme Court Collegium and High Court Collegium. What does Supreme Court Collegium do? The Supreme Court Collegium does two things. One, it appoints judges to the Supreme Court. Second, it transfers the High Court judges, right? At the same time, we have something known as High Court Collegium, which does what? It does appointment to the respective High Court. These are the two bodies which are responsible for appointment and transfer of judges, right? Now, how does the appointment happen? Appointment can happen from bench to bench. That means you can elevate an existing High Court judge to Supreme Court. At the same time, the collegium has power to appoint someone who is practicing advocate with required number of years to become a Supreme Court judge. Both are appointment. One is bench to bench, another is bar to bench appointment, right? Now, these are the things. Let's talk about composition. The composition of Supreme Court Collegium is 5 usually, and the High Court Collegium is 3. But sometimes the Supreme Court Collegium's composition can increase to 6. This is something that we got to see late last year, December, right? December 2022, marked something wherein the collegium strength increased from 5 to 6. Now, how does this happen? Usually, collegium of Supreme Court consists of the Chief Justice of India and four senior most judges of that court. That means Supreme Court, right? But sometimes this strength of 5 is increased by 1 in order to incorporate or in order to include the one person who is going to be the next Chief Justice of India. So what I mean to say is the usual strength is Chief Justice of India and other 4 senior most judges. That is 5. But if within this 5, the next Chief Justice of India, usually we know who is going to be the next Chief Justice of India. Right now we know that Sanjeev Khanna is going to be the next Chief Justice of India. We also know that after Sanjeev Khanna, we are also going to see the first woman Chief Justice. So we know what is going to be the order of Chief Justice. So what happens is if the present collegium doesn't have the next upcoming Chief Justice of India as one of its member, then the strength can be increased by 1. The same thing that happened in December, Sanjeev Khanna was included in the collegium, right? That is usually the play of strength. Now let's talk about what is going on in news, right? The news is that the government wants to bring some kind of influence. They want to participate in this process of appointing judges. Now, if you look at the original provision of the Constitution, which is Article 124(2), it says that the President of the India shall, after consulting such number of judges of the Supreme Court and High Court, shall appoint such number of judges as are required to the Supreme Court. That means who shall appoint? President. After consulting with such number of judges as he thinks fit, right? Now, what happened was, if you see, there was this era where the central government started rewarding those judges who were giving favorable judgment to them. If you remember the ADM Jabalpur, Shivkant Shukla, ADM Jabalpur versus Shivkant Shukla, which is the case popularly known as the habeas corpus case. There we saw that how one of the judge who gave a dissenting judgment, who disagreed with the stance taken by the central government or who went against Indira Gandhi, he was punished and he wasn't elevated. Although he was expected to become the next Chief Justice of India, he wasn't elevated, rather his junior was elevated, right? So we see that the government can influence the judges and they can reward them based on whether or not the judge is supporting them in the case, right? Now, to remove the influence of government and to make judiciary truly independent. Now, one of the basic structure of the Constitution is that the judiciary has to be independent. Independence of judiciary is one of the key feature or what is known as the basic structure of the Constitution, which cannot be compromised with, right? This was the Keshavanand verdict. So after which there were three judgments. The first one, SP Gupta, second, Advocates on Record versus Union of India, and third, in re special reference. All these three judgments delivered by the Supreme Court introduced the concept of collegium. It said that we cannot compromise the government or the legislative or the executive bench interfering into the appointment matters or into the judiciary, because judiciary has to be truly independent. So in order to maintain those independence, the judiciary themselves created a body known as collegium, which will take into interest the best which has to be given to the judiciary, and accordingly it will appoint the judges. The president has a very minimal role, the government has a very minimal role. They have nothing to do. They have to listen to what the Supreme Court is saying. It can at best keep these recommendations made by the Supreme Court or High Court collegium at abeyance. That means they can keep it at stay, but they cannot negate it completely. They cannot, just disagree and say that we won't appoint, because the final call is taken by the collegium. Right now, the central government wants to involve themselves into this procedure. Therefore, they have included something known as NJAC. Now, this is the composition of NJAC. If you look at the composition of NJAC, we have Union Minister of Law, the body which is going to appoint judges, which it will have a law minister, right? At the same time, it will have other people from the legislative and the executive wing as well. Now, with this, the legislative wing and the executive wing taking over or participating in the appointment of judiciary will actually destroy the independence of judiciary. That's why after those three judges case, something known as popularly as the fourth judge case, it's not, but people call it, right? In this verdict, apart from Jasti Chalmeshwar gave a dissenting verdict. Otherwise, all the other judges, including K.M. Joseph, Justice Adarsh and Justice K.M. Joseph and Madan Lokur, all of these people said that NJAC is straight away compromising with the concept of independence of judiciary, which is the basic structure of this constitution. So it cannot be compromised, and hence NJAC, the 99th amendment and the NJAC, it is invalid and they removed it. So collegium sustains even till date. We have to see what happens in future. Will there be further push by the government in order for them to be, one of the stakeholders in appointing the judges, right? Now, with that, we come to the end. I hope that this video was useful. You can always use the comment box in order to, ask any kind of question with regard to this topic or in general, right? Thank you so much. Have a nice day.